A very good morning to all my dear students. I welcome you today for the second class of Companies Act. So I hope all the CA Foundation students, you have revised your first lecture that we have done of Companies Act. We have already started with Companies Act. And today we'll be proceeding further in Companies Act. Akshit wants to ask something the very early morning before even we start the lecture. You have a query. Yes, Akshit, you can speak if you want to speak something.
Ma'am, chat is closed, ma'am. How can I answer?
I know because you students at times try to be naughty. That's why they have closed it. So let me just ask help from technical support. Sir, can they get the option of chat or they have to type on the admin query pad? Good morning, Vishwas, Pavan Kumar, all of you.
Ma'am, good morning, ma'am. Good morning, ma'am.
Good morning. Mohammed, Neharika, Amit, all of you. So, Akshit, you can write down your queries on this admin query pad. The chat box is not working currently. So, you can write down even Mohammed, Neharika, Amit, Pavan Kumar, Vishwas, they all are writing over here. So, you can use this query pad at the admin portal. All right. Okay. Now, let's begin today's session. So, as always, before we start with the new session, we have a quick recap of what we have done in the previous lecture. So, let's have a quick revision of what we have done. So, we have already discussed what is a company. So, when we started the definition of company, I told you all the features of the companies relate to the definition of company. That is, company has a separate legal entity, it is a body corporate, it has a perpetual succession, and it has limited liability. It is an artificial legal person. So my question relates to the topic of common seal. So it is an optional for the companies to have common seal. Akshit, you still want to speak something? You have put your hand raised. You can just lower your hand, Akshit. So now if you want to proceed, that if you have taken an option of common seal, then you will be using a common seal for your documents that you're signing in the company. But if you have not opted for the common seal, then what is the option available for the company? What is mandatory? The signatures of who all is required? So you all have to answer me. Good morning, Mr. Abdul, Almas, Mohammed Shafi, all of you. And the students over here, Tanushri, Ria, Latha, Almas, Anil, and Anspa. You can also give the answers on the query pad. Manyata, Natasha, Satyajit, Hemlata, all of you children. Okay, so two board of directors have to sign. Very good. Pavan Kumar is the first one to give the correct answer. Or one director or one company secretary needs to sign the documents. If you are not opting for the common seal, then it is mandatory for these people to sign the documents. So any doubts you have in the corporate veil theory, children, we have discussed about the corporate veil theory also in the previous lecture. And also there were different cases. So you have to tell me what are the 5 exceptions where the separate legal entity concept is not considered, means the 5 cases that we have learned where the company and the shareholders are treated as one. What are those 5 different cases? So quickly answer me in the admin query. Niharika Kumari, good, Almas, Anushka, good, I'm getting your answers. Ms. Bairam, you want to say something? You have sent the link of Zoom, so you can join on Zoom as well. All right. So Salomon versus Salomon and Company Limited, it was specifically laid down that company is different, shareholders are different, but we did 5 exceptions to this rule. So what were these 5 exceptions? Number 1, to determine the character of the company. If you're trading with alien enemy, then the corporate veil is lifted and you will be treated as one. If you're trying to evade the taxes of the government, then also the corporate veil is lifted. And if you're trying to avoid any legal obligation, where we did discussed about the bonus that was not given to the employees and the formation of subsidiaries to act as agent, even if you're forming any fraud or improper conduct is being done by the companies, in all these cases, the corporate veil is considered to be lifted. So now you need to give me the answer for the case law that we have discussed about protecting the revenue. What was the specific case law where we have talked about tax evasion? There was Mr. So-and-so who was trying to evade the taxes. He has opened 4 private companies, invested in different companies. Tell me the name of the case law. We are just revising what we have done, children. Those who have just joined right now. So I'm asking you questions and you need to revert back to me on this admin query pad. Yes, Mr. Vedant Gupta, that's great. So what is the name of the case law? Now you all have to tell me the name of case law. I'm waiting for your answers, children. All of you have to write down. So the case law where it was written that the person has made 4 different private companies just to avoid his income, showing his income in order to avoid paying the taxes. And in return, he has taken a loan from those companies. What is the name of this case law? Excellent. All of you have given the correct answer. Dinshaw Manekji Petit is the correct answer. Very nice. Pavan Kumar has a question. Ma'am, the definition for these exceptions are not much. So how can we write? So Pavan Kumar, you can write down these exceptions in your own words. It is not mandatory to learn it word to word, but if you have understood it, you can explain it in your own words. All right. So everyone is clear about this. Daimler Company Limited versus Continental Tire and Rubber, where we have started about the alien enemies when the German citizens have formed the England company and they cannot have during the World War, they were not allowed to have trading relations with the England. And Guilford Motor Company versus Horn was for fraud and misconduct, where somebody is trying to solace the customers of the previous company. So the previous company filed a case against them that you are not supposed to do such kind of things and such kind of acts. So everyone is, I hope, 100% clear about these case laws that we have discussed in the previous class. Now, testing of your knowledge also happened. We have discussed all these questions in the previous class. Today, we'll be starting with a new topic that is different types of companies, what we called as classes of companies. So by what do we understand by the word classes of companies means how many types of companies do we have? So first types of companies that we are going to do is on the basis of liability. On the basis of liability, it is company limited by shares, company limited by guarantee, and unlimited company. Earlier, we had the discussions about the incorporation also, but registered, statutory, and chartered companies. Now it has been removed from your syllabus. So we specifically start from the company limited by shares, company limited by guarantee, and the unlimited companies. So let me open the study material so that we can do the word to word from these. All the types of companies will be discussed in detail. So this is your first category of companies on the basis of liability. What do you understand by the word liability? Liability is the main thing that we have understood in Companies Act is that company has a separate legal entity concept. So company is different, shareholders are different. Company will have to bear its own liability. There is no personal liability of the shareholders. Like you were partners, then you have your personal assets are also held liable in order to pay off the liability of the partnership firm. But this is not the case with the company. Company's liability is separate from the liability of the shareholders. So first is the case of company limited by shares. Now, company limited by shares tells you where is the liability of the members of the company stated. Where is it written? So it is specifically written in the memorandum of association. So keep underlining these words that I'm telling you. Underline the word MOA, that is memorandum of association. Similarly, company limited by guarantee also, where is the liability of the members written? It is written in the memorandum of association. So memorandum of association will write that the liability of the members is limited, either limited by shares or it is limited by guarantee. Clear? So first point is clear. Where it is written in the MO. So if I ask you, do we write the liability in the AOA for the limited liability? Yes or no? Do we write the liability in articles of association or memorandum of association? Yes, Mr. Vishwas Bhav sir, that's right. Shareholders liability is limited. That's good. Tell me, children, fast you have to answer me. Try using this admin query pad also, children. You know where to log in and where to write and where to type. So don't take too long to answer back. Once you start answering and using it, you will feel the same comfort as you used to feel in the chat box. Okay. Okay. So yes, all of you have given the correct answer. No, ma'am, it is not mentioned in the articles of association. It is mentioned in the memorandum of association. Now, what is the liability in case of company limited by shares? In case of company limited by shares, the liability is limited up till the amount unpaid on the shares held by them. What is the meaning of the unpaid on the shares? If any, अगर कोई रहता है तभी उनकी liability होगी. If they are fully paid up shares, then there is no liability. So what is the liability? Liability is the amount unpaid on the shares held by them. So Vedant Gupta, listen to me. I'm going to give you an example. Then you'll understand the query that you have raised. So if there are shares of 5,000 shares I have taken in ABC Limited and each share is of rupees 10 each. So what is my share capital? 5,000 into 10, 50,000 I need to pay. But I said, okay, right now I just have rupees 8 per share I'm going to pay. So I have paid 5 8s of 40. So 40,000 rupees I've already paid to the company. How much is the amount which is unpaid on the shares? How much is the amount that is unpaid on the shares? Yes, children. Rupees 2 per share. So now, whenever the liability of the company will arise, I only need to pay 5,000 into 2, that is 10,000 rupees will be required to be paid by my side. All right. So now you have understood. So liability is the unpaid on the shares, means how much balance is left to be paid by the shareholder. That is only his liability that can be called upon at any time during the lifetime of the company or during the winding up. So for meeting the debts of the company, shareholder may be called upon to pay this amount which is remaining unpaid on his shareholding. His separate property is not required to be paid. So you cannot say if the liability of the company is 1 lakh rupees. How much I need to contribute if I'm part of company limited by shares? How much amount I need to contribute? Tell me. Only rupees 10,000. Very good. So I don't need to pay for the balance 90,000. Company will meet its own liability. That is the meaning of limited liability. Although the shareholder is a co-owner, but we are not co-owner of the company's assets. Like in partnership, we all were joint owners, but we are not joint owners of the company. If you have taken one share in Reliance, does not mean that you become the owner of the Reliance company. It's assets, okay? Ownership remains with the company because it is a legal person. So Reliance Limited will have the ownership with them. The rights and duties of the shareholder as a co-owner is depending upon his shareholding. How is his shareholding? That will determine his rights and duties and liabilities. Is that clear? You can write down on the side of this paragraph, company limited by shares, the shareholder can be called upon. The shareholder can be called upon to pay for the liability, to pay for the liability at any time during the continuation of the company, at any time during the continuation of the company or during the winding up. Winding up means when you're closing the company, then also you can be asked upon to pay the liability. So when can you ask the shareholders? Either during the continuation of the company or during the winding up of the company. But what is the case of company limited by guarantee? In case of a company limited by guarantee, you can only be asked upon to pay the money at the time of winding up. It says in the later case, you can only be asked to pay the money in case of winding up. So you can write down on the side of company limited by guarantee. In case of company limited by guarantee, the members can be asked to pay the amount only at the time of winding up. Now, again, this liability is mentioned in the memorandum of association. Members may undertake by the memorandum to contribute towards the asset only in the winding up. So point number 1 is MOA. Point number 2 is only at the time of winding up this liability incurs. And point number 3 is liability will be amount mentioned in the memorandum. They cannot be called upon to pay beyond a stipulated sum. What is the meaning of stipulated sum? Stipulated sum means a fixed amount. What is the meaning of guarantee, children? I have given you a guarantee that if you buy if Mr. B buy goods from you, I am giving the guarantee that if B fails to pay, Harleen ma'am is acting as a surety. She will pay on behalf of Mr. B. So this is the guarantee that I gave the guarantee up till rupees 5,000. So tomorrow he fails to pay 50,000. I am liable only for rupees 5,000, the guarantee that I've given. So guarantee is a fixed amount that you have made assured to the other person that I am going to pay this much amount. Similarly, A, B, and C, they have formed up a company, ABC Private Limited. So they formed the company limited by guarantee. So each one of them have given the guarantee that in case of the company goes into winding up, A says, I will pay 10,000. B says, I will give 5,000. C says, I will give 2,000. So now if the liability is 1 lakh, you can only ask A to pay 10,000. You can only ask B to pay 5,000. And how much can you ask Mr. C to pay? Yes, children, tell me. Yes, you have to answer me. Since the chat box is closed, I'm surprised you have stopped answering me back in the admin query. Children, this is not done. So you have to answer in the admin query. You have to reply back because this is the way that we have been doing. And this helps me to understand that you are understanding and staying awake. With your replies, I can make it out. Okay, very good. So all those who have answered, only 2,000 rupees Mr. C will be required to pay. That is absolutely correct. So only 2,000 rupees Mr. C can be invited to pay. So everyone is clear about company limited by shares. You pay the unpaid amount in the shares. Company limited by guarantee, you need to pay only the amount that you have agreed to pay. What is the common features of both of them? Both of them are legal personality and they have limited liability. Both their liabilities mentioned in the memorandum of association. So what are the common features? Common features means what are the common points? Both of them are legal personality. Both of them have limited liability and the liability is mentioned in the memorandum of association. What is the difference between these both companies? You tell me. I've already told you the difference. What is the difference between? Soumil Arora is asking, ma'am, what is the difference between guarantee and warranty? So guarantee is the surety that you're giving. Warranty is referring back to your sale of goods. You must have done implied warranty where you have breach of conditions and breach of warranty. So warranty is specific that you have given for the time period that you're giving the warranty for certain things. There you can only claim the damages. But guarantee is when you're giving a surety about the payment of the sum to other person. Okay? All right. So now what is the difference between these two? You have to tell me, children, what is the difference between company limited by guarantee and company limited by shares? Both of them work on a different footing because one, in case of company limited by shares, the liability is unpaid on the shares and it can be called upon at any time. Very good, Mr. Abdul, Miss Anushka, Niharika Kumari, Vishwas Bhavaskar, only Satyam Dubey. Only these children are answering. What about others? You have not understood that you're not answering. So when can I call upon the company limited by guarantee? Can I call them to pay the liability during the lifetime of the company? The answer is no. They can only be invited to pay off the liability only at the time of winding up. It says only at the time of commencement of winding up means जब company को बंद करना शुरू कर दिया जाता है, then only they can be asked to pay. Good, Mr. Vedant Gupta. Now we are going to do a very interesting case now, Narendra Kumar Agarwal versus Saroj Mand. Although it is not very important case now, but since it is given in the study material, it helps you to differentiate between the company limited by shares and company limited by guarantee. So it is required to have a reading to this. Now all these two paragraphs are related to this respective case law, Narendra Kumar Agarwal versus Saroj Mand. It says it is clear from the definition of guarantee company that it does not raise its initial working fund from the members. No working funds are needed and they come from the endowment fees, charges, donations. What is the meaning of endowment fees? Endowment fees means certain people are giving you a charity that this amount shall be used only for this specific purpose. So an agreement is made where they tell you that this is the amount 10,000, suppose I'm giving to some certain society and I'm doing a charity and I'm telling them that this is the amount which should be used only for this particular purpose. But other fees, charges, donations, you're just giving it as a charity to another person. So company limited by guarantee children is generally a charitable kind of organizations which don't people don't invest their own money. It does not raise its initial funds from members. Means suppose A, B, and C have started up company limited by guarantee. So it's not that A and B and C have to bring the capital from home. They will what the capital initial investment will be from the endowments, fees, charges, donations they get from different funding people. They get from other sources. And they have given the guarantee that I will pay 10,000, 5,000 and 2,000. Same example. Now when the company will go into winding up, then only A, B and C will be required to pay their money, not during the initial working capital. But what is the case of company limited by shares? There too you're bringing the share capital. Like you're taking up the shares in the company and you're paying the amount for the share capital. So Supreme Court has laid down that right of a guarantee company to refuse to accept the transfer by a member of his interest on the companies on a different footing than the company limited by shares. Guarantee company carry many privileges than those of the ordinary shareholders. Now, what is the meaning of this line? It says company which is limited by guarantee has a privilege. Privilege means benefit. What is the benefit that is given to a company limited by guarantee? Number one, this shareholder, shareholders will be called only at the time of winding up to pay off the liability. But what is the case of ordinary shareholders? Where the company is limited by shares, they will be asked to pay the liability anytime during the winding up or even during the continuation of the business. Now, let's assume there was a company which is limited by guarantee and limited by shares both. There were three shareholders, ABC. They have taken up shares in the company and it is a company limited by guarantee having share capital. So ABC have given the guaranteed amount and let's assume D and E are the shareholders. So what is the difference between the member of the company and shareholders? So when you become the member, when your name is entered in the register of members, you become member of the company, and only when you take up a share in a company, you become a shareholder. So D and E are the shareholders. They have invested money in the company. They are the shareholders. A, B and C have only given the guarantee. Now, the privilege of the guarantee company is that whenever the company will go into winding up, first Mr. D and E will be asked to pay their amount on the unpaid amount on the shares. And still, if any liability is left, then A, B, C, who are the guarantors, they will be asked to pay the amount. So this is the privilege which is given to a guarantee company, that their liability occurs after the ordinary shareholders have paid off their liability, which is restricted to the unpaid amount on the shares. And guarantee company refused to accept the transfer by a member as interest and was on a different footing. It says company limited by shares. There is a restriction on the transferability of the shares. You cannot transfer your shares freely, but this restriction is not there in case of a guarantee company. So Narendra Kumar Agarwal versus Saroj Malu, you simply have to remember in this case law, they have not given you the briefing of the case law. They have just given you the conclusions of this case law. What benefits guarantee company has? Number one, their liability is incurred only at the time of winding up. Number two, they're liable only up to the amount that they have guaranteed to pay. Number three, their shares are not restrictions on the transfer of the shares as we have in case of company limited by shares. So there's certain advantages. And number four, you can also remember that the guarantee company does not raise its own working fund. It gets its funding from the endowments, fees, charges, donations. So basically, these two paragraphs are talking about the benefits that are available with the company limited by guarantee over the company limited by shares. Is that clear, children? All of you, everyone is clear about this? Okay. I'm glad, Mr. Vedant Gupta, you have understood it now nicely. That's great. Yes, Mr. Vishwas, you can say that it covers the full amount, but again, you have to have clear definitions about this. If you refer to warranty, that is as it is warranty that you have done in your sale of goods. Okay. So now we talk about the unlimited liability. What is the unlimited liability company? So Companies Act give you the privilege of setting the company limited by shares also. Company limited by guarantee also. Section 2, clause 22 says company limited by shares. Section 2, clause 21 talks about Company Limited by guarantee. Mr. Pavan Kumar and Satyam Dubey has also written cleared and understood clearly. So that's great. And Section 2, Clause 92 gives you the right of the Companies Act to create a company which is having unlimited liability. So you can have a company with unlimited liability also. What is the meaning of unlimited liability? The way we have unlimited liability in case of partnership, the same case is the unlimited liability, no limit on the liability of members. So for reading, instead of reading this, you can simply read over here. Only important point over here is, here the liability is mentioned in the articles of association. For the limited liability, it is mentioned in the memorandum liability clause. And for the unlimited liability, the articles will state the amount of share capital and the amount of each share for which he is liable. So where is the liability mentioned? In case of articles of association. So liability, there is no limit on the liability of members means they are can be called upon to pay. Their personal assets are also liable. Liability ceases when he ceases to be a member. What is the meaning of ceases? Ceases means ends. So Harleen ma'am is member of ABC Private Limited. If I get my name strike off from the register of members, I quit for the company, I leave out from the company, then I'm no longer liable. So my liability is only till the time I'm associated with the company. If I've left the company, then my liability also comes to an end. Liability is not unlimited till the company is wound up. Means when does your liability occurs? At the time of winding up of the company, not during the continuation of business. So if Harleen ma'am is part of ABC Private Limited and she is the part of unlimited company, when would I need to pay for my liability? Only when the company goes into winding up. Winding up means closure of the company. Now you're closing the company. So members can be asked to contribute only at the time of winding up and not during the lifetime of the company. Liability of members extend to the company's assets and liabilities. However, we can also claim from the members. What is the meaning of this line? That although whatever the company's assets and liabilities, everything will be held liable to the outsiders, but even the members can be asked to bring their personal assets from the home in case of unlimited liability. So like in partnership, you were paying your personal assets also. If the liability was not sufficiently met, then your personal assets also become liable. Similar is the case of the companies. If you are not paying the liabilities from your funds, then personal assets of the members needs to be brought in order to pay off the liability of the company. Is that clear? So where is the liability of unlimited company mentioned? Memorandum or articles? Who is the official liquidator? It is written official liquidator may call the members for their contribution. Official liquidator trial whenever the company goes into winding up means company goes into closure. Then an official liquidator is appointed. Liquidator means who helps in the liquidation of the company. He is appointed by the court and he is invited. He will sell off all the assets of the company and pay off the liabilities of the company. So while paying these liabilities, he will be calling the members to contribute towards their liabilities. Is that clear to everyone? Any doubts so far? Okay, no doubts. Everything is clear. So let's proceed ahead. Now we are coming to a very, very important topic. Yes, unlimited companies do exist. There can be a number of unlimited companies depending upon the liability that they have decided to take upon. So sole proprietorship generally has the unlimited liability. So in just to overcome this unlimited liability, we fell into a partnership. But even after partnership, we have the unlimited liability. So we went to LLP. So even in case of the unlimited liability of the company, the owner will have to bear his own liabilities. There is no separation of the liabilities. Although in case of unlimited company, the separate legal consent will be existing, but there will be an extent beyond which they can pay to their liabilities. Okay, there can be many unlimited, like Johnson and Johnson is a parent holding company. It has a subsidiary, Janssen Pharmaceutical. So there can be many companies which are unlimited companies. But most of the companies like Apple and all, they are majorly limited liability companies. Okay. It is mentioned. Yes, Anushka is giving the correct answers. Niharika Kumari is giving the answers. Natasha is giving the answers. And others are wondering whether we need to answer back or not. So good answers given by all of you. Mr. Vishwas, Articles of Association will mention the liability in case of unlimited liability. Okay, partnership, second stage OPC. Yes, that's great. So after partnership, we decided that we will move to LLP because our liability was unlimited. So we decided to open up an LLP. But what if I tell you that for partnership, how many people are required minimum? Tell me. For partnership and even for LLP, how many people are required? Minimum requirement is how much? 5, 6, 8, 10, 7. How many? How many people are required to open up a partnership? Minimum number of people required is 2. Everybody has given the correct answer. Minimum 2 people are required in order to open the partnership. But if I am a single person, I don't want to have any partnership. Then what will I do? How will I manage my business? So single person, what would you open up? He will always open up a sole proprietor. Is that clear to everyone? If I'm a single individual, I cannot enter into partnership. If I'm a single person, I cannot have a company. Because for private company, I need 2 people. For public company, I need 7 people. So government in year 2013 thought that what about this single individual? Can you see this Uncle Ji holding a bag in his hand? This is a single sole proprietor. And he was really curious and worried that how can I do a business? If I open up a sole proprietor, then I have huge unlimited liability. I don't want that unlimited liability burden. And I don't even want to enter into partnership with anyone. I want to be my own sole proprietor only. I want to do my own entrepreneurship. I want to do my own business. So what did government thought of coming up with? Government thought of introducing to a new class of company which can be formed by a single person. So now this single person, just to encourage the entrepreneurship and corporatization of business, means instead of opening a sole proprietor, he was given the advantage of legal entity with a limited liability, and hence he was told to open up an one-person company. So this Uncle Ji opened a one-person company having a separate legal entity with limited liability concept. So Companies Act 2013 has given a new class of company, a birth was given to a new class of company where a single individual avoiding the burden of sole proprietorship. Why? Because in sole proprietorship, his liability is extending to beyond his official and personal assets. जो आपके घर के assets है वो भी liable हो जाते हैं आपकी liabilities pay off करने के लिए. But once you become a company, you have a separate legal entity. So this Mr. Uncle Ji who was holding the bag, he's a separate person. The company that he will form, a Private Limited, that is a separate AOPC. So what is the words that you use behind OPC companies? OPC, like you use private limited for private companies, you use word limited for public companies. Behind OPC companies, you use the words OPC. So everyone have understood why OPC came into existence. Section 2, clause 62 defines one OPC is a company which has only one person as a member. This is the only company where single person can be a member. It is no requirement of minimum 2, minimum 7. Only single person is required to open up a company. So you don't have to go and ask anybody else to become your partners. For LLP also you needed partners. Now I'm sitting at my own home. I can form an OPC. I can do my business, having the advantage of separate legal entity also and limited liability also. The procedural requirements are simplified through exemptions given in comparison to other form of companies. So it says OPC, if you set up, number of exemptions are given to OPC. So when you go to CA Intermediate is hub of Companies Act. You have 10 to 12 chapters which are specifically related to Companies Act. I told you in CA Foundation, you just do minimum 23 to 25 pages of Companies Act, just laying down the basis and foundation. Again, in the chapter 1 preliminary of CA Intermediate, you will be covering these definitions in detail. But for your foundation, the syllabus is very much limited. So there, when you will read Companies Act in detail, we will tell you that there are certain exemptions. What is the meaning of exemptions? Means आपको ये चीज करने की जरूरत नहीं है, आप exempt है. So what are you exempt? So OPC has been exempted from many compliance and procedures. Like for example, financial statements, you have to prepare balance sheet, profit and loss account, cash flow statements, all these kind of statements you have to prepare when you prepare your financial statements under Companies Act. But OPC is exempted from preparing cash flow statement. So there are many other kind of exemptions which are given to the OPC, and also the setting up of OPC is very simplified. You don't have to go into much of the complications like you have to go in case of a private company and a public company. And public company, when it plans to list itself, then it has more things to follow like SEBI and listed company provisions, all this. But OPC, as a very simple company, it has number of exemptions given to it under the Companies Act. So section 3, subsection 1, clause C defines OPC. OPC is a private limited company. Very, very important point. So if I ask you, can OPC be a public limited company? Yes or no? Can we have an OPC which is a public limited company and it is coming up with the shares to be put up in the market? Niharika Kumari, absolutely OPC exists in India. That is why they have introduced it in Companies Act 2013. Since 2013, many companies have formed up OPC. So single person can also form a OPC. Mr. Mohammed Shafi, I hope now you're clear. OPC is only a private limited company. Good. Abdul, Pavan Kumar, Vishwas, Satyam Dubey, Natasha, Anushka, Vedant Gupta. Finally, children have started answering. Miss Almas Z. Good. 2 people were required in that case. Nice. So OPC is a private limited company. It can never be a public company. But can you convert it into public company? Yes, it can be converted either into private or public company, but OPC is always a private limited company. Yes, concept of shares may not come in hand. Good. So minimum paid up share capital, as we have described, having one member as a shareholder, only one member. So one person is only the member. Minimum paid up capital, no limit has been prescribed. So section 3 says that the OPC shall be open up with a minimum paid up share capital. This much is required, but what is required? No limit has been given as of now. Okay. Memorandum will indicate the name of the other person who, in case of death of the subscriber, become the member of the company. Now, please write down in front of this third point, nominee of OPC. NOMINEE, nominee of OPC. What is the meaning of the word nominee? If you have opened up your fixed deposits, if you have taken up FD in a bank, you must have seen whenever you open up a saving bank account or any account with the bank's fixed deposit account, they ask you for the nominee. What is the role of this nominee? That tomorrow, if I am no longer there, whatever is my bank balance or whatever is my FD balance, that shall be given to that nominee. Understood? Everyone knows the meaning of nominee. Same is the case of OPC. It is mandatory in case of OPC to appoint a nominee. That tomorrow, if Mr. A is running the OPC, if he dies, then Mr. B, who has been named in the memorandum, that Mr. B will be taking over the OPC, because it is only one member now. In case of other companies, you have so many members. So anyone can become the other shareholders are still existing, company is still existing. But OPC, who will take over? Mr. B, whose name has been given in the memorandum, will take over the business of Mr. A. So nominee is the person who will take over the business in place in case of a death of the owner of the OPC. This other person whose name has been given shall give a price. So who is this other person? You all have written down nominee. Who is this other person? Nominee whose name is given in the memorandum. He will give his written consent and the same needs to be filed with the ROC at the time of incorporation along with the e-memorandum and e-articles. What is e-memorandum and e-articles? Now we have electronic filing of the memorandums and electronic filing of the articles of association. So a written consent of this nominee also needs to be filed with the registrar of companies. What is registrar of companies? ROC. So it is a body with which we have to get a self-registered when you incorporate a company. Tomorrow, when we will next lecture, we'll be doing about the steps for incorporation. So I'll tell you how the company is incorporated. You have to file all your documentations with the registrar of companies and a certificate of incorporation is given to you. So for doing all these filings, a written consent of the nominee also needs to be filed in case of an OPC with the ROC. Such other person may be given the right to withdraw his consent. So who is the person we have named? Mr. A OPC is there. He has named Mr. B in the memorandum that he will be acting as the nominee. A written consent will be taken from Mr. B and that written consent is to be filed with the ROC. Can Mr. B withdraw his consent? Can Mr. B say this tomorrow that no, I don't want to be a part of OPC. I no longer want to be part of OPC. Can Mr. B say that? Does he has a right to withdraw his consent? Yes, ma'am, or no, ma'am? Jaldi se batao. Can Mr. B withdraw his consent? Yes, ma'am, he can withdraw his consent. He can anytime say that I don't want to be a nominee anymore. Then you quickly need to appoint somebody else. Member can also change Mr. A, who is member of OPC. Here he is talking about Mr. B can withdraw his consent. Yes, he can withdraw his consent. Can Mr. A change the name of the OPC? Yes, Mr. A can also change. Okay, yes, Mr. A can also change. Let's assume Mr. A says, I am not happy with Mr. B. I don't want him to be my nominee. Now I want Mr. C to be my nominee. Then he will change the name of this nominee. He will give a notice to the company and also send the notice to the registrar. So he will give a notice to the company that now a company will record in its make entry in its record that now Mr. C is the nominee and the same also needs to be filed with the ROC. Any such change shall not be the alteration in the memorandum. Now, what is memorandum of association? What is memorandum? What is the meaning of memorandum? Memorandum is the charter of the company. It is the main document which contains all the details about what kind of business we are doing, what is our name, what is our liability, everything is mentioned in the memorandum. Now, again in CA intermediate, you will understand about the alteration of memorandum. It is a very huge process. Section 13, 14, 15, 17 applies when the memorandum needs to be altered. So it is a very detailed thing that needs to be done to alter the memorandum of association. Your registered office is changing, your object is changing, whatever things are happening. But law tells you that does this change in person of the OPC, does it require the alteration of memorandum? The answer is no. When you're just changing the name of the person of the OPC, you do not need to alter the memorandum. This is just a minute change. You simply need to inform the company and send the intimation to the ROC. You don't need to alter the memorandum of association. Is that clear? So all these 5 points relate to the nominee of the company. The first 2 points are very simple. Only one person can be appointed as the member. The minimum paid up share capital, there is no limit has been laid down for the minimum paid up share capital. Nominee's name is to be given. Other person, nominee, has to file his written consent. He can withdraw his consent. If I'm changing from Mr. B to Mr. C, I need to give the notice to the company and intimate the registrar also. And does it require the alteration in the memorandum? If I've changed the nominee from Mr. B to Mr. C, do I need to alter my memorandum of association? Yes, ma'am. No, ma'am. What now? Yes, children. No, ma'am. Alteration in memorandum is not required. Very good. So now, who can open up an OPC? Now, the next question is, who can? Now, this is very important question. This is basic thing on the basis of which examiner is going to ask you question. So only a natural person, Mr. Divyansh Bhatti, good, now you have started replying. Vishwas Satyam Dubey, Abdul Pavan Kumar, Mohammed Shafi UK, Vishwas, Great. Who can open up an OPC? So now whatever I'm going to tell you, keep writing down, marking down the points. Number 1 point is only a natural person. Point 1 karo isko. Point 2, Indian citizen. Point 3, whether resident in India or not. Point 4, stayed in India for at least 120 days. Point number 5, during the immediate preceding financial year. So there are 5 points in this small line. Only a natural person. What is the meaning of point number 1? Can a company open up an OPC? Can an artificial person, can a firm, can they open up an OPC? The answer is no. Only a natural person, an individual can only open up an OPC. सिर्फ एक इंडिविजुअल, एक ह्यूमन बीइंग, एक इंसान ही ओपीसी खोल सकता है. He needs to be an Indian citizen. Can a foreign citizen open up an OPC? Mr. R is a foreign citizen. He decides to open up OPC. Can he do that? Yes or no? Can a foreign citizen open up one-person company in India? No, ma'am, because law specifically says that only Indian citizen can open. Now, whether he is resident in India or otherwise, you don't need to matter what is the residential status, whether he is NR, resident, NR, ROR, OR. That is something that you will understand. And income tax. So, Indian citizen होना जरूरी है, natural person, individual होना जरूरी है, whether he is a resident or non-resident in India, that does not matter. For how many days he should have stayed in India? What matters is he should have stayed in India not less than 120 days, means 120 or more than 120. Even if you have stayed in 120 days, then also it is fine. Not less than 120 days, means minimum 120 days or more, you should have stayed in India. And when does we need to stay in India? During the immediately preceding financial year. What is the financial year that is going on right now? 24-25. April 24 till March 25. What is the immediately preceding financial year? April 23 to March 24. So what is the time period I need to see? Immediately preceding financial year. So one is assessment year, one is financial year, one is previous year. So as per income tax, assessment year is the year which is ahead of the continuing financial year. Here we are simply referring to the preceding financial year. So if I'm asking you today, can I open up an OPC on 10th December? Can I open up an OPC? You need to see my status, that whether I've stayed in India from 1st April 23 till 31st March 24. If I have stayed in India for 120 days or more, then only I'm eligible to open up an OPC. Vedant Gupta is asking, ma'am, American stayed for 120 days. Can't become, but if NRI is opening, then he can. So if American, he's a foreign citizen, he cannot open up an OPC. You keep staying for 120 days, 100 days, whatever you want. Indian citizen can only open up an OPC. Number 1. If you are an Indian citizen, but in the previous year, if you have not stayed for more than 120 days, then you cannot open up an OPC. It has nothing to do with your residential status, whether resident in India or not. What is important is you are a natural person, you are Indian citizen, you have stayed in India for more than 120 days during the immediate preceding financial year, go and open up an OPC. You're allowed to open an OPC. And the same conditions are applicable in order to become a nominee for the sole member of OPC. So Mr. B, जिसको हमने nominee बनाया था, he shall also be an Indian citizen. He shall be a natural person, stayed in India more than 120 days during the preceding financial year. Then only he can become the nominee in OPC. So अगर Mr. B also stayed in India for 80 days, can he become the nominee of OPC? Mr. B stayed in India for 80 days only. The rest of the days he was traveling to Singapore, Dubai, America. He was not in India for more than 80 days. Can he become the nominee of the OPC? Yes, ma'am. No, ma'am. And why, ma'am? It is taking too long. We have to finish the types of companies, children. I have not received any answers till now. So no is the correct answer. Those who have written no, that's great, because minimum 120 days condition is for the nominee also. Good. Now, Mr. Ranil, Natasha, Almas, Yash, Divyansh, everybody has given the correct answer. 120 days, the criteria for the financial year is. Mr. Muzammil Khan, 120 days is for the condition for the previous financial year. So the year about which we are talking is preceding financial year respect to that year. Okay, so if we are in 24-25 right now, so I have to see your number of days for 23 to 24. 1st April 23, say 31st March 24. If you have stayed for more than 120 days, then only you're eligible to open up an OPC. Miss Alpa, ma'am, according to law, 120 is the definition of resident, so it is not necessary to say 120 days. So, Miss Alpa, it is not necessary. It is trying to tell you that at least 120 days. It is not important to see your residential status. What is the residence as per OPC? That is 120 days condition needs to be seen. That is what is important. Okay. Yes, Gauri wants to ask something. Better you speak. Yes, Gauri.
Ma'am, nominee also should be a resident of India or
Yes. Not resident of India. What is the condition? Condition is he shall be an Indian citizen. Whether resident in India or otherwise means we are not bothered about the residential status. What are we bothered? Nominee should also be an Indian citizen. If Mr. A OPC is opening and Mr. John a foreign citizen, can he be my nominee? Yes or no? Mr. B is a foreign citizen.
Yeah, ma'am. Yes,
can
ma'am.
he be my... No, he cannot be my nominee if he's a foreign citizen. Yes. Okay. Understood, Gauri?
Yeah, ma'am. Thank you, ma'am.
Okay, welcome. No person shall be eligible to incorporate more than one OPC or become nominee in more than. So you can open up only one OPC and you can be nominee in only one OPC. Minor cannot be a member in OPC. Such companies cannot be converted into Section 8 companies. What are Section 8 companies? Section 8 companies are the charitable companies. OPC can never be a charitable company. But they can become private or public limited companies, but they can never be a charitable company. And neither the OPC can carry out NBFCs or investment in securities. So you cannot do these mutual fund related kind of business also. OPC cannot do this. So OPC is one-person company, private in nature, encouraging the entrepreneurship, simplified procedures, separate legal and limited liability. This is your definition. If it comes for OPC, we have done the points related to nominee of OPC. And this is very important, which tells you who can open up an OPC. So I've already answered, Gauri, your query. Now I'm going to ask Yashna. Yes, Yashna.
Ma'am?
Yes.
So actually, I have a doubt regarding the residency. According to law, residency meaning itself is staying less than 120 days, no, ma'am.
Okay. So yes, I will tell you. So there is a problem in this thing that if you go to Income Tax Act, there is specific requirement saying that a person is a resident in India if he has stayed in India for more than 182 days. But under Companies Act 2013, the only requirement for the Indian citizen to open up an OPC is that you should have stayed in India for 120 days. So you can avoid reading that line, whether resident in India or not. It simply tells you a natural person, Indian citizen, stayed in India for 120 days or more, immediately preceding financial year, then only you can open up an OPC. And only these conditions met, then only you can be a nominee of OPC.
Okay, then if he doesn't stay for 120 days, he cannot become a member or
No, then he cannot become a member of OPC, then he cannot become a nominee of OPC.
Okay, ma'am. Thank you so much, ma'am.
Okay. Yes, Ankit Singh.
Ma'am, what is the meaning of the alteration of the memorandum?
Okay, I will tell you. Okay, I'll just tell you. Yes, Divyansh, you also want to ask something?
Ma'am, OPC 1% company है. OPC is a 1% company.
1% company.
दो कैसे क्या एक तो मेंबर और दूसरा नॉमिनी वो नहीं समझा.
Interesting question. Mute yourself. नॉमिनी क्या होता है पहले? You want me to explain you in Hindi? I will explain you in Hindi. नॉमिनी होता है कि अगर कल को मेंबर नहीं रहा What is written in case of death of the subscriber of OPC? Means अगर मिस्टर ए की डेथ हो जाती है तो कौन टेक ओवर करेगा ओपीसी को? मिस्टर बी, जिसको आपने नॉमिनी अपॉइंट करा. तो सेम टाइम पे ए एंड बी नहीं चला रहे ओपीसी को. मिस्टर बी विल कम इन टू पिक्चर ओनली व्हेन ए हैज डाइड. Okay, Divyansh? Then only the nominee will come into picture, not all the time. I hope everyone is clear about that. Mr. A and B are not running the OPC together. It is sole member, only one person. When he dies, Mr. B will take. Okay, now I think Mr. Ankit, your question is left. Alteration of memorandum. Yes. So alteration of memorandum means to change the memorandum of association. Memorandum is a very big document. It has your name clause, object clause, registered office clause. बहुत कुछ होता है. It is the main constitution of the company, the charter of the company, जिसमें सारी details company की दी होती. Now, section 13 to further sections talk about how the memorandum is altered. Alter मतलब उसे change करना, उसे बदलना. But ओपीसी में नॉमिनी के नाम को चेंज करने में हमें मेमोरेंडम को बदलने की जरूरत नहीं. This much only he is trying to tell you, that you don't need to alter means you don't need to change your memorandum of association just because you're changing your nominee.
Okay, ma'am.
All right, clear?
Okay, ma'am. Clear.
Okay. Anybody else want to ask their doubts? Please, children, raise your hands, because then it becomes very much easier for me also to listen to your queries. If you want to ask. Divyansh, I hope your doubt is clear. Vedant Gupta, government must wanted only Indians to open. Yes, Vedant, that's why they have made it condition that it is only Indian citizen. Miss Alpa, I hope your doubt is clear. Can minor? No, Niharika. Minor cannot become the member of OPC and not even the nominee of OPC. So let's take a small break here, children. All of you will now go through the points that we have done, and rest we will discuss further. Let's take a small break. students? I hope you have read OPC and no other doubts in OPC now. All the doubts were answered. Anyone still wants to ask anything can ask. Otherwise, we are proceeding further now to the new topic, that is private and public companies. Let me see the students over here. All right, everybody have understood. Now let's understand what is a private company. So children, private and public company, you have heard about these companies earlier also. Private company, what we have to remember is minimum 2 people are required and maximum, it says except in case of OPC. OPC is the only private company which starts with 1 person and can go up till only maximum 1 person. The other person is only the nominee. He's not doing the business along with it. But in any other private company, minimum 2 people and maximum 200. It limits the number of members, means you cannot have more than 200 members in a private limited company. 2 or more persons holding the shares in a company jointly, they will be treated as single member. So if I ask you, Mr. A and B are holding jointly, the shares are being held by them. So, and there are 10 more members. There are 10 members of the company. And A and B are jointly holding. A is the 11th member, B is the 12th member. They are jointly holding the shares. So we have in total 10 members plus 1 or plus 2. A and B will be counted as 2 members or they will be counted as 1 member. So total will be 11 or 12. Tell me. If A and B are jointly holding the shares. Yes. Good. So it will be 11 members because 2 members will be treated as 1. They will be counted as when. So it will be, Mohammed is saying 2 members. No, beta, you will be counting that 1. That is what is the meaning of this line. That if 5 shareholders are holding jointly, the shares are held by 1 together, then also 5 members will be counted as 1. So how many people are holding the shares jointly? They will be treated as a single member. Further, it says people who are in the employment of the company. Let me just open from my presentation for all of you. So this is your OPC. We have already done private company, public company. So minimum 2, maximum 200 and excluding the present as well as the existing and past employees. So if you're employee of the company, either earlier you were employee of the company or even presently if you're an employee of the company, sometimes you're a shareholder also and you're an employee of the company. So if you're an employee of the company, you will not be counted in the limit of 200 members. Another point is restricting the right to transfer on the shares. Private company restricts the transfer of the shares. You cannot transfer your shares freely to anyone else. And also there is a prohibition on inviting the subscribe to securities. So you cannot go to the public asking them to take up shares in your company. You're a private limited company. You can have minimum 2 people, maximum 200 people. Can a private company go and get their shares listed? Can they go to the public? Can they come up with the initial public offer that I want to subscribe? I want public to take up securities in my company? No. There is a prohibition on the private company. Private company can never go out to the public asking for securities. So what are the 3 important points of private company? Number 1, it limits the number of members to 200. It restricts the transfer of shares. You cannot transfer the shares to anyone outside. And third is it prohibits the invitation to the public for security. Minimum requirement of the paid up share capital, no limit has been prescribed as of now. And what is a public company? Public company is very simple. Public company means a company which is not a private company. So अगर private company learn हो गया तो public company already जो private company नहीं है वो public company. So with word private limited is used for private company and for public company we use the word limited. No requirement of, Gauri, let me just complete and then I'll give you a chance. Minimum paid up capital, no requirement of minimum paid up capital. Minimum 7 people, maximum unlimited number of members. So is there any limit on the number of members of public company? No, there is no limit. All right. Subsidiary of a public company is deemed to be a public company. So if you are a public company and you have a subsidiary, then that subsidiary shall also be deemed to be a public company. Means that will also be considered as a public company. All right. Yes, students. Subsidiary of a public company shall deem to be a public company means that if I am a company and I am a holding company and AB is my subsidiary company. If I am a holding company, PQ Limited, I am a public company and my subsidiary. What is the meaning of subsidiary? We'll be doing in a while. What is holding and subsidiary? As of now, just understand that AB Private Limited is my subsidiary company. Now, this AB Private Limited will also deem to be a public company because the holding company is a public company. So, if any company which is holding the private company, that is a public company, then that subsidiary company shall also deem to be a public company. Yes, Gauri, you want to ask something?
Ma'am, difference between government company and public company.
Okay, we'll be doing government company in a while, then I'll explain. Okay. As of now,
Okay.
just understand what is public and what is private.
Okay, ma'am. Thank you.
Okay. So private company is clear, children, everyone. 3 important points. Jointly held up shares will be treated as one member. Maximum 200 number of members. Restriction on the right to transfer the shares and prohibition of inviting the securities to the public. What is public company? Number 1, which is not a private company. Minimum 7, maximum unlimited number of members. And if you are a subsidiary of a public company, then even if in your articles you continue to be a private company, but you shall deem to be a public company, means all the compliance, everything you have to do will be as per the public company requirement. All right. Okay. Now let us understand what is a holding and subsidiary company. If a company is controlling the composition of board of directors, controlling the composition of board of directors means if A Limited is deciding how the directors of B Limited are to be appointed, how they are to be removed. So you can write down controlling the composition of board of director means company is deciding about the appointment and removal of board of directors. Deciding the appointment and removal of board of directors. Then it is known as controlling the composition of directors. All right. Or you're having more than 1/2 of the total voting power you're holding in another company. Means you're controlling more than 50% of the share capital or more than half of the total voting power in another company. Then that company will become your subsidiary company. For example, if we talk about Tata Limited, the major international acquisitions, they have international subsidiaries, Tata Steel Europe, Tata Steel Thailand, Nat Tata Steel Holdings, Singapore company. And other subsidiaries are Tata Metalics, Tata Steel, TRL, Kerosky Refractories Limited. All these are the subsidiary companies. Means Tata Limited is holding more than 50% of the voting power of these companies, or it is having controlling the composition of board of directors. So either of the things if you are doing, it will consider to be as if you are controlling the another company, then the other company becomes your subsidiary, and the company which is controlling the composition of board of directors will become the holding company. Let's read it from the study now. I'll just come back to small company. Let me just finish off with the holding and subsidiary relationship, because then only you will understand this point of subsidiary of public company. So company is said to be holding company if it has more than one subsidiaries, it is controlling the board of directors, or it is controlling half of the total, or is very important. Either of the points if you're doing, you will be considered as a holding company. A company shall deem to be the subsidiary even if you are following subclause 1 or subclause 2. Composition of board of directors, I already told you, appointment and removal of directors. Company includes body corporate. Layer means subsidiary or its subsidiary means A is holding B, B is holding C. So if A is a subsidiary of B, if B controls the board of directors of A, means B, without the consent or approval of A, cannot appoint or remove the director. That is what is the meaning of holding and subsidiary relationship. A will be a subsidiary of B if more than 50% of the share capital is being held. Now, if we say that B is a subsidiary of A and C is a subsidiary of B, so A is holding B, so B is a subsidiary, B is further holding C. So C will automatically become the subsidiary of A also. So this is how you can have the layers of subsidiary. Now, since you have understood the meaning of holding and subsidiary, now this line becomes very, very important for you. A status of a private company. It says private company. What is example? AB Private Limited is a subsidiary of PQR Limited. Write it down. AB Private Limited is a subsidiary of PQR Limited. So PQR Limited is public company. AB Private Limited is private company. Then AB Private Limited shall deem to be a private public company. It shall deem to be a public company for the purpose of this act, even if it continues to be a private company in its articles. Means as per your articles of association, you will be private company. From your mind, body, soul, you're a private company, but for all the compliance of this act, you will be treated as if you're a public company. So whatever procedures, compliance is applicable to public company, they will become now applicable to AB Private Limited. Now, anyone has any doubts in holding and subsidiary, this point they can ask. All right, clear everyone? Okay. Yes, Gauri, still you have a doubt? Ask.
Ma'am, holding company, it is like a parent and subsidiary company is like a child, ma'am.
Yes, absolutely correct.
Okay, ma'am.
Okay, so now if your parent company is a public company, so the child will also be treated as a public company, even if it is a private limited.
Okay, ma'am. Thank you.
Okay, all right. Now let's understand what is associate company. Associate company is very, very important. It means a company when a company has a significant influence on another company, but which is not a subsidiary company. It says you are not a subsidiary, but you're having a significant. If you're a subsidiary, then you're seeing the 50% share capital. So what is the meaning of having a significant influence? The meaning of significant influence means if you're controlling at least 20% of the voting power of another company or you're participating in the business decisions. So what is the meaning of associate company? Significant influence is there, not subsidiary. Significant influence means at least 20% of the total voting power or participation in business decisions. And it also includes joint venture. So if you have a joint venture, then also you both are associate companies. For example, A Limited and B Limited are having a joint venture. Will you call them subsidiary companies or associate companies? If A Limited and B Limited are having a joint venture, will you call them associate companies or subsidiary companies? Very good. You will call them associate companies. If A Limited is holding 25% of the voting power of B Limited, what is the relationship between A and B Limited? If A Limited is holding 25%, very good, Abdul. No, Mr. Abdul, it is not the reverse case where private company is a subsidiary, is a holding company. It is only written in the act when public company is your parent company, then only you deem to be a public company. Okay. Pavan Kumar, yes, if you are a subsidiary of a private company. No, again, it is not a subsidiary of private company. It is talking about being a subsidiary of a public company. Very good. This is an associate relationship. When one company is holding more than 20% of the total voting power of another company, then they're said to be associate companies. Absolutely correct, all of you. And if A Limited is taking part in the business decisions of B Limited, then also both of them will become the associate company. Now, my last question in respect of this is AB Limited is holding 49% shares of BC Limited. Is it a subsidiary relationship or associate company? AB Limited is holding 49% of the share capital of BC Limited. Is it an associate relationship or it is a subsidiary relationship? Everyone has to answer this one. Absolutely correct. From 20% till 49%, it will be considered as the associate company. Only if it is more than half, that is 50%, then only you have the relationship of holding and subsidiary. And what is the important line? More than half of the company. So more than 50%, till 50%, it is the associate company. So if it is holding more than half, then it is holding and subsidiary. And what is listed companies and unlisted companies? Listed companies are the companies whose securities are listed on the stock exchange or they are in the process of listing on the stock exchange. So you have National Stock Exchange and Bombay Stock Exchange, two important stock exchange we have in India. If your securities are listed over here, then you are a listed company. And what is unlisted company? The company whose securities are not listed on the recognized stock exchange are the unlisted companies. Yes, Gaurav.
Ma'am, if a holding company is a private company, then subsidiary company can become private company?
No, it is not talking. The act is silent about private company being the parent company. It is simply telling you when the public company is your parent company, then the private company shall deem to be the public company.
Can
Okay.
a company become a holding company?
Private company, it is very difficult to, private company will hold a public company. So private company is never holding a public company. It is public company which is holding, investing the shares in the private company.
Okay, ma'am. Thank you.
Okay. Yes, Neil Kothari, you want to ask something?
No, it's small company, ma'am. Small
Yes,
company.
we are going to do small company from the study material after doing government company.
Okay, ma'am.
Okay. Okay, now what is government company? At least 51% of the share capital. Now, please remember in holding and subsidiary, you're holding 50% of the share capital. In associate company, you're holding 20% of the voting power. What is the stake of government in government company? Please note it down. 51%. It is not saying 50%. It is saying at least 51% of the shares held by central government or state government or partly by central or state government will be said to be a government company. So if Mr. Rex, the person of state government, is holding 47% of the shares in AB Limited, if government is holding 47% of the shares, state government is holding, can you call it a government company? Madhav Bansal is asking, ma'am, how to join the class. You can ask me your queries here also, Madhav. No problem in that. The Zoom link is given on the admin portal only. Ma'am, public company can be subsidiary of private company. So only if the private company is a subsidiary. Miss Kavita Gunjal, when the private company becomes a subsidiary, then only this applicability comes up. Tell me, children, will it become a government company, yes or no? Public company can never be a subsidiary of private limited company, children. How can a public company become a private company, which is a subsidiary, will get the status of a public company? Public company cannot be a subsidiary of private limited. Okay. Yes, Mr. Abdul, very nice. They can be an associate company, but not government company. But here we are talking about the government company holding a stake. Okay, so it is not a government company since it is less than 51%. Okay, good. Madhav Bansal, Anushka, Divyansh, Abdul, Vishwas, Natasha, Mohammad Shafi, Niharika Kumari, Pavan, Almas, Muzammil, all those who are answering back, very good children. So now listen to the question carefully. 25% of the shares are held by state government in AB Limited. and 20% of the shares are held by, 25% of the shares are held by central government. So 25% are held by state government and 25% of the shares are held by central government. Will now AB Limited become a government company? Yes, ma'am, or no, ma'am? No, ma'am, because both of them are jointly holding only 50% of the stake. Then also it is not a government company. So if state government is holding 47%, central government is holding 5%, then it is more than 51%. Then yes, it will become a government company. But 51% is the total stake that needs to be seen. It includes a subsidiary of government company means if I am a government company, AB Limited is a government company, and I am holding 50% of the shares of PQR Private Limited, then PQR Private Limited will also be considered as a government company. If I am a government company and I have any subsidiary, then that subsidiary will also become government company. If I am a public company, I have any subsidiary, then subsidiary will also be deemed to be a public company. पेरेंट कंपनी पब्लिक है तो सब्सिडरी भी पब्लिक है, पेरेंट कंपनी गवर्नमेंट है तो सब्सिडरी भी गवर्नमेंट. बट अगर मैं गवर्नमेंट कंपनी हूं and I'm holding 45% shares in AB Limited, will AB Limited become subsidiary company? Well, first of all, if I am a government company, Harleen Private Limited is a government company. Harleen Limited, sorry, not private limited. Private company kaise ho jayegi government company? So if Harleen Limited is a government company and this company is holding 45% shares in AB Limited, are we having holding subsidiary relationship? Yes, ma'am, or no, ma'am? No, ma'am. So will AB Limited will be considered as a government company? Yes or no? I'm holding 45% shares of AB Limited and I'm a government company. Will AB Limited consider to be a government company? Yes, ma'am, or no, ma'am? Jaldi batao. Vishwas is saying, ma'am, at least 51% to become private or government. Mr. Vishwas, I am already a government company. If I want to make my subsidiary a government company, first of all, I have to make AB Limited my subsidiary. So for making that subsidiary, I should be holding more than 50% of the share capital of AB Limited. So since I'm not holding more than 50%, therefore it is not my subsidiary. Therefore, AB Limited will not be a government company. As it is question paper में question दिखता है आपको, we will be doing it from the question paper also. कंपनीज एक्ट में ऐसे ही क्वेश्चंस आते हैं बेटा, होल्डिंग सब्सिडरी के रिलेशनशिप के ऊपर, गवर्नमेंट कंपनी के स्टेक के ऊपर, एंड देन कंबाइनिंग बोथ द होल्डिंग एंड सब्सिडरी. सो टू नेक्स्ट लेक्चर वी विल बी टेकिंग अप दीज एग्जामिनेशन पेपर क्वेश्चंस आल्सो. All right. No, ma'am, is the correct answer for that one. Very good. Natasha, Niharika, Kavita, Divyansh, Vishwas, Muzammil, Almas, Anushka, all of you have given the correct answer. Kavita is asking if central government is holding subsidiary, then yes, you have to see for the government company, you have to see 51% of the shareholding. For holding and subsidiary, you have to see 50% of the shareholding. Now let's understand small company. The definition of small company is given under section 2, clause 85. Small company is a company which is having a paid up share capital exceeding 50 lakh rupees. Why we have not taken up this from my presentation? Because it is clearly given it over there. Yes. So small companies other than a public company. Before small company, we have foreign company and section 8 companies we'll be doing in a while. Small company is other than a public company. That means small company is always a private company. Other than a public company means it is not a public company. So it is always a private company. Paid up share capital shall not exceed 50 lakhs. Turnover will not exceed 2 crore rupees. So what is the limits that you have to learn for small company? The minimum limit for a small company is your paid up share capital shall be up to rupees 50 lakhs and your turnover is up till rupees 2 crore. Then only you become a small company. So do I have to learn these limits of 4 crores and 40 crores, whatever is mentioned, 2 crores and 20 crores written over here? So if you'll see the amendment, it tells you that the paid up share capital and turnover shall not exceed 4 crores and 40 crores. Now children, listen very, very carefully. The limits which is given is the paid up share capital shall not exceed 50 lakh rupees or such higher amount as may be prescribed. वो कहते हैं आपकी पेड अप शेयर कैपिटल की जो लिमिट है वो 50 लाख रुपीस होनी चाहिए या फिर सच हायर अमाउंट as may be prescribed. So government has the right to prescribe the higher amount, but it shall not go more than rupees 10 crores. So what is the highest amount they have prescribed as of now is 4 crore rupees. What is the highest amount that they have prescribed is 4 crore rupees. Okay. And what is the amount that has been prescribed for the turnover? It says turnover if it is 2 crore rupees or such higher amount as may be prescribed. And what is the higher amount that they have prescribed is 40 crore rupees. So if I ask you what is the final condition that you have to learn for the small companies, 4 crores and 40 crores respectively from 15 September 2022. Earlier, before 2022, this limit was 2 crores and 20 crores. Now they have decided the fixed limits of 4 crores and 40 crores is the higher limits which have been set up for the small company. So small company is always a private company. This is the paid up and turnover limits that they have given 50 lakhs and 2 crores, but the maximum limits that you have to learn for the exam is 4 crores and 40 crores. Can a small company be Section 8 company? No. PCB का भी Section 8 company नहीं हो सकती. Small company can also be not Section 8 company. Can we have holding and subsidiary of small company? No. Small company cannot be a holding company, neither it can be a subsidiary company. Is that clear? So these are the limits of small companies. So what you have to learn is 4 crores and 40 crores is the final limit. It is always a private limited company. It is not a public company. Now let's quickly go through the foreign companies. This listed companies also we have done. This is your limits, 51% of the share capital for government company. Foreign company is a company or body corporate incorporated outside India and having a place of business in India. So foreign company, you have a detailed chapter in CA Intermediate where you discuss sections, all the sections related to foreign company and a very descriptive and detailed definition under section 2 clause 42 is a foreign company. Here you simply need to remember it is a company which is incorporated outside India. So I incorporated a company in Singapore and I have a place of business in Delhi. Then it is a foreign company. But if I have formed a company in Singapore and I have a place of business in Singapore only, it has nothing to do in India, then it is not a foreign company. If you have formed any company which is incorporated outside India, banai bahar hai, but place of business in India, how is that place of business? Either I am having any office or through an agent, I am having a place of business. By whatever mode I am having a place of business in India, then it becomes a foreign company and you conduct the business activity in India. So both the conditions have to be seen and business activity is being conducted in India, then you become a foreign. Let's take a small break over here because then we are going to wind up with Section 8 companies. Just go through. If you have any doubts, you can write down in the admin query. All right, let's continue, students. This is your new module, study material, in which it is exact definition that I was telling you is given. So your paid up share capital, the maximum limit that you have to learn is now this is what you have to learn. So paid up share capital should not be more than 4 crores or the turnover not more than 40 crores. So there is or between both of them. Either of the condition is met, you will be treated as small company. So my question to all my dear students is, if I am a company AB Limited having a paid up share capital of 3 crores and my turnover is 80 crores, can I be treated as a small company? Yes or no? If I'm a company AB Limited having a share capital of 3 crores and my turnover is 80 crores, will I be treated as a small company? Very good. Muhammad, Muzammil, Anushka, Vishwas, all of you have given the correct answer. No, ma'am, is the correct answer. Why? Because I am a public company. A private company can only be a small company. So now the next question is, if I am a company ABC Private Limited and I'm having a paid up share capital of 2 crores and my turnover is 50 crores, do I become a small company now? My paid up share capital is 2 crores and my turnover is 80 crores. Do I now become a small company? Tell. Natasha, Kavita, Vishwas, Abdul, it is the correct answer for the previous one. Now do I become a small company or not? Please tell me, children, hurry up. ABC Private Limited, having a turnover of 80 crores, having a paid up share capital. Okay, why are you saying no, children? All those who have given the answer no. So if your paid up share capital is up till 4 crores or the turnover is not more than 40 crores, then you become a small company. Either of the condition needs to be met, children. So even if I'm a private company, I'm having my paid up share capital 2 crores. If my turnover is more, still I become a small company. It is not the word and, it is the word or which needs to be seen in both these conditions. Shoaib Ali, the figure of 100 crores and 10 crores which is given over here, these are the upper limits which the government has given. It means that tomorrow if we want to increase the paid up share capital and the turnover, then we can increase it. Then we can increase it up till 10 crores and 100 crores. Okay. And this and word has to be seen, children. Yes, that's correct. So both the conditions have to be met. Paid up share capital and the turnover has to be seen. So no was the correct answer for both the questions. The first answer was no because it was a public company. So you cannot be a small company. And even if private company is just meeting the paid up share capital limit, not meeting the turnover, then also you will not be a small company. Both the conditions of 4 crores and 40 crores need to be met in order to be a small company. Is that clear, everyone? So it should have been written and over here. It should not be the word or. Okay, now let's proceed to the last topic of today's discussion, that is Section 8 companies. So what is Section? Yes, Gauri, you want to ask something. Speak, beta.
Difference between private company and government company.
So private company, again, you have to remember those points. Why do you mix up the private company with the government company? Government company है जिसमें government का stake है. Private company में अगर government का stake होगा तो it will become a government company. Otherwise, it is a private company in itself.
Not
which follows
company, public company and government company. Government is considered as a public. Public is considered as a government. Then public company.
Not at all. Wait. Public company means where you are going out to the public, you are investing your shares, you're issuing a prospectus, you're asking public to invest money in your company. You are having a public stake, but if you're having a stake of government, then you become a government company. Public company is entirely different. Public company may be a government company, may not be a government company. So public means your public at large is having a stake. I can understand where you're trying to connect it. It seems as if public company means government has invested. So if government has invested, then that public company is a government company. Okay,
Okay,
otherwise
ma'am.
public company we study in comparison with the private company. हम 2 लोग हैं, हमने प्राइवेट कंपनी खोला, हमें मिनिमम 7 मिल गए तो हमने पब्लिक कंपनी खोला. गवर्नमेंट हमारे अंदर 51% स्टेक होल्ड करती है तो हम पब्लिक कंपनी, गवर्नमेंट कंपनी. अदरवाइज पब्लिक कंपनी कैन हैज इट्स ओन इंडिविजुअलिटी. ऑलराइट.
Okay, ma'am.
Okay.
Thank you.
Okay, beta. Now let us understand Section 8 companies. Section 8 companies, children, पहले जैसे Section 25 companies होता था, NPOs, non-profit organizations. Similarly, Section 8 companies, now they have given the name of Section 8 companies. They are formed with the charitable objective. Charitable objective means they don't have the motive of earning profits. They are working for the charity kind of purposes. So these companies are formed for promoting sports, arts, education. For example, in your state where you're living, there is a company formed up in order to promote the artwork. So they have set up a company. We want the children to participate in different artist kind of competitions, paintings, or maybe we want to promote football. So any football association has been opened up just to encourage the children to come and play the games. So all these kind of companies like FICCI, SOCHAM, National Sports Club, CII, these are examples of Section 8 companies which are simply working for the objective of the company and they do not give any dividend to its members. So Section 8 companies are only for promoting its charitable objectives and they use their profits for promoting their object and they don't give dividend to the members. So if I say Section 8 companies is giving dividend to our members, then it is not valid. It is not correct. They cannot give dividend to its members. Section 8 companies can use the word limited, it has a limited liability, but they're not required to use the word limited or private limited. They simply work by getting a license from the central government. So who is going to, so it's a very important company, you know, children. Section 8 companies, they have to make an application to the central government. So if Harleen ma'am wants to open up a company, Harleen Sports Club of India company, then I have to make an application to central government that I want to open up Section 8 companies. Please give me the permission. I will submit all my objective. This is my objective where I need to apply the profits and I prohibit for paying dividend to its members. I am not for a profit motive company. I am a non-profit organization which is opening a company. Central government is satisfied that I am a legal company, then only it will give me a license. On the basis of license which I get from central government, I can operate as a Section 8 company. A registrar will make an association, will register such persons as a company. On registration, you will get the same rights and privileges as you get to a limited company. Okay, on registration, the company will get the same registration privileges and obligations of a listed company. Now, what is important over here is revocation of license. If this Section 8 company is found to do any kind of fraud or it is violating the objects of the company which are against the public interest, means you have started giving dividend to your members or you're doing something which is illegal. You are a sports association, you were to promote football, now you have started selling and purchasing of clothes also. You are violating your objective. Violate करना means objects के खिलाफ जाकर कुछ काम करना, means public interest को hurt कर रहे हो, कुछ भी गलत कर रहे हो. So registrar will simply cancel your license that they have given to you and they will put the word limited or private limited after your name. Now either you become a limited company or private limited, you are no longer a Section 8. But before doing this, central government will give a written notice and opportunity of being heard will be given. They will send you the notice. National Sports Limited Club of India, notice will come that you are violating the provisions. You will be converted. You want to say something in lieu of that, you can come and speak. Opportunity of heard matlab sunwai ka mauka dena. They will be sending them a notice and opportunity will be given to them to speak. Central government's order will be a final order. They can either ask them to amalgamate yourself. Now, what is central government? Central government will go to the National Sports Club. They will tell them either you amalgamate yourself with another company which has similar objectives or you just wind up your company. So two options will be given to them that you merge yourself, amalgamate yourself. कोई ऐसी कंपनी है जो सेम ऑब्जेक्टिव के साथ बनी है, आप या तो उसके साथ मर्ज हो जाओ, या पब्लिक प्राइवेट कंपनी बन जाओ, या फिर आप कंपनी को वाइंड अप कर दो, मींस कंपनी को खत्म कर दो बिकॉज आपने फ्रॉड करा है या फिर वायलेट करा है. And any contravention, if you make Section 8 companies, a very severe hardship is given. If you make any contravention, then a fine which can extend to 10 lakh rupees and can extend up till 1 crore rupees. It is the major fine in Companies Act, children. 10 lakh to 1 crore rupees will be fined to you, to the company, and the officer in default will be fined with 25,000 to rupees 25 lakh rupees. Also, they will be held liable for action under 447. 447 is your CA intermediate part. It is the liability for fraud. Any person, any company which is doing or committing fraud is held liable under section 447. अभी के लिए हमें लिमिट्स नहीं याद करनी 447 की, बट हाँ 447 एक फ्रॉड के लिए सेक्शन बनाया गया है जिसमें सिवियर पनिशमेंट एंड लाइबिलिटी एंड इम्प्रिजनमेंट, जेल भी होती है 3 साल की या 5 साल की. सो अगर आप सेक्शन 8 कंपनी की कॉन्ट्रवेंशन करते हो, कंप्लाई नहीं करते हो, तो 10 लाख to 1 crore कंपनी को फाइन लगेगा, 25,000 to 25 lakh rupees ऑफिसर इन डिफॉल्ट को फाइन लगेगा, एंड ऑल्सो दे आर लायबल फॉर 447. So here is your summary of section 8. It is formed for promoting the commerce, sports, art, science, religion. It has the minimum share capital does not apply. Profits shall be used only for objectives. We cannot declare dividend. It operates under a special license that you get from the central government. Can you use the word limited or private limited? No, there is no requirement of using the word. Chambers, clubs, these kind of words can be used for section 8. When does the license get revoked? If few conditions are contravened, if you are violated the provisions, if you do any fraud. What happens on revocation? Either you convert yourself into public or private company, change your name, or you wind up or you amalgamate with another company. If you're calling a general meeting, now all these points are again of your CA intermediate syllabus when you call a meeting, but simply you have to learn when we call a meeting, we generally give 21 days notice for calling a meeting. But here, if you're a section 8 company, you simply need to give 14 days notice. You don't have to give 21 days notice, 1 week priority, you only have to give 14 days notice. There is no requirement of directors, independent directors in this case. Nomination and remuneration committee is also not applicable. And last point is very, very important. Partnership firm can be a member of section 8 company. Now, what is the meaning of this line? Partnership firm can be a member means, when I told you about OPC, only a natural person can open up an OPC. Company cannot open up an OPC. Neither a firm can open up an OPC. So firm एक आर्टिफिशियल पर्सन है, एक आर्टिफिशियल पर्सन भी नहीं है. फर्म मीन्स अ जॉइंट नेम विच इज गिवन टू द पार्टनर्स. सो आई टोल्ड यू अ कंपनी कैन स्टिल बी अ मेंबर, बट अ फर्म इज नेवर अ पार्टनर इन अ पार्टनरशिप फर्म. रिमेंबर? But Section 8 company gives the permission to be a partnership firm and also join as a member to Section 8 company. Means there are 5 people, A, B, C, D, and E, who have decided to open up Section 8 companies. You don't need the word limited and private limited after your name. There is a firm ABC Associates. Can this firm ABC Associates be also a member along with ABCDE to Section 8 companies? Yes or no? Can we have this ABC Associates partnership firm can also become a member or not? Shoaib Ali, I hope you understood that query of 100 crores and 10 crores. Vishwas, railway government. Yes, Vishwas. That is the different examples of the railway government companies that you have. Section 8 companies has nothing to do with trust, Divyansh Bhatti. So trust is different thing. Section 8 companies, different things. So just simply understand what is Section 8 companies, okay? Yes, it's an important point. That's great. Yes, Abdul, partnership firm can become member. Good, Shoaib Ali, Muzammil, Vishwas, Abdul, Mohammed. All of you have given the correct answers. Our Hindu Biswas has sent a query. ABC Limited has 1 lakh paid up share capital and its shares issued as a holding company. You can claim the status of. Yes, if you're a public company and you're holding the shares of private company, then yes, the private company will also become the public company. It shall deem to be a public company. All right, children. So with this, we have come to an end of today's session. If you have any doubts, you can raise your hand. Gauri still has a doubt. Yes, Gauri.
Section 8 companies are like non-profit organizations, ma'am.
Yes, absolutely correct.
But trust are so different, ma'am. Sports trust and these kind of trust are different.
Yes, from trust is nothing to do with the Section 8 companies. Trust is something different. Trust means मैंने अपना पैसा किसी trustee को दिया है beneficiary के लिए. So that you don't have to understand as of now. Section 8 companies has nothing to do with the trust.
Okay, ma'am. Thank you.
Anybody else having any doubts? I hope you enjoyed today's session, children, and you have learned the different types of companies. Now your homework is that you have to revise all these types of companies, make your written notes, and we'll try to do examination questions in the next class. And also we'll be covering the balance chapter in the next class. Thank you so much for being a wonderful audience, and I hope you don't have any doubts as of now. Akshit wants to ask something. All right. Yes, Akshit.
And for this only the ICI material we have to refer or any other
Yes.
thing?
ICI module is the Bible for CA Foundation students. You don't need to refer to any other book. Everything is covered over there. But yes, whole of the module needs to be covered nicely. Don't leave a single thing. Along with
Ma'am,
that, you can refer to my presentations.
Presentation you will send, ma'am.
Yes, here it will be uploaded. Don't worry. Yes, Ankit Singh.
Ma'am is forming like a private company, public company. In case of NRI, there is any limit to be staying in India in some days like 120 or
No,
21?
there is no limit.
There is no
There is
limit?
no such condition for the public and private companies to be formed.
Okay, ma'am, when foreign company incorporated business in India, so what way did they do? They form subsidiary companies
Your
in
Hotstar, your Netflix, all these are foreign companies. They don't have to come into India present. They can be electronic mode also. So all these are foreign companies. किसी तरह से भी आप business कर रहे हो, चाहे agent के through कर रहे हो, चाहे electronic mode में कर रहे हो, you become a foreign company. Or Microsoft, Google, all these are foreign companies.
Ma'am, they form subsidiaries in India, like
You can form, yes, they can have subsidiaries in India.
Okay, ma'am.
All right. Anybody else? If you have any doubts, you can ask children. So I hope you all have understood. You have enjoyed the lesson. And now I see you in the next class. That is day after tomorrow. Till then, goodbye.
Hello, ma'am.
Abdul has written something. Yes, Akshit, you want to ask something? Hurry up.
Ma'am, webinar for Partnership Companies Act, I found it was not there. You can tell the date,
It will be
ma'am.
coming up soon, maybe on 17th or 19th. I can't recall the date, but it is there. Okay.
17th, 19th. Link is not given
Link
anywhere.
will be coming. That technical team will help you with that. You can ask the administration at ICAI. Okay.
Administration Act, ICIA member, ma'am.
Yes, you can ask them.
I don't have their phone number. That's why I asked.
All right. You can just check it with them. Beta. The way you check for other queries at ICAI, you can just check it with them. All right. All right. Thank you so much, everyone. And I see you on day after tomorrow. Abdul, you can ask me this query that you have written. We'll do this. We'll try to cover this in the next class. All right.